Then, after the First Amendment, the next 9 amendments list in both chronological and order of magnitude the risks and dangers to the ideal commonwealth. The second and third deal with what they understood correctly to be the greatest threat to a democracy, to a tolerant democracy anywhere, and that's military overthrow. You don't have to, can look anywhere in the world. You know, you look in Latin America, you look in the Middle East, you look anywhere, and you realize that the greatest threat to a tolerant democracy is the military overthrow. And the Second and Third Amendments are designed to deal with military overthrow problems. The Fourth through Eighth are a remarkably coherent chronological description of the next danger, which is the danger from civilian law enforcement. It is no coincidence, I suggest to you, that the Fourth deals with investigation, the Fifth deals with interrogation, the Sixth and Seventh deal with adjudication, and the Eighth deals with punishment. You could not get a more careful and beautifully put together picture of the chronological development of a law enforcement situation than the Fourth through the Eighth. Maybe it's random that they happen that way, but no other rights-bearing document in our cultural history has that order. Whether you go to the English Bill of Rights, to any of the colonial charters, to any of the revolutionary constitutions, to the Declaration of the Rights of Man, nothing has anything like that. And my suggestion to you is that Madison's genius was not necessarily substantive. It was structural. It was his capacity to see, and the capacity of the other founders, to see a structural a blueprint for how you create a tolerant democratic society and how you protect that tolerant democratic society from a series of dangers that are placed in chronological and order of magnitude. And then why close the Bill of Rights with the 9th and 10th Amendments? We are currently mired in a terrible dilemma because the extreme readings of both amendments either give them too much power or no power. Either we read them out of the document entirely or we essentially read them as blank checks for judges. My suggestion is that the founders did what you would expect brilliant people like that to do. The 9th and 10th Amendments are metacanons of construction. They tell us at the end of the document how to read it. And they tell us how to read it against the background of British hermeneutic tradition that went back to Henry VIII, that went back hundreds of years. British parliamentary lawyers, and the founders were well-trained British parliamentary lawyers, all knew that there were two ways of looking at text. There was the equity of the statute way of looking at text, which expanded text analogically and filled lacunae with non-textual expansions. And then there was the Inclusio Unis way of looking at text, which said that if it was in the text, you couldn't, if it was not in the text, you couldn't expand it. And they didn't know, because you could see from the British tradition that the British lawyers and judges yawed back and forth between equity of the statute and Inclusio Unis in the way they read their parliamentary commands. So the founders told us in the Bill of Rights itself, when rights are at stake in the 9th Amendment, equity of the statute is permissible. You can fill in gaps. You can use analogical reasoning to fill in gaps to make sure that the Bill of Rights didn't do what we were nervous about doing, which is to freeze rights before we had really understood the full need for them in a democratic society. On the other hand, the 10th Amendment adopts Inclusio Unis and says where powers are at stake, you cannot use analogical reasoning. You must stay directly inside the text. And I suggest to you the interplay between a broad reading of rights and a narrow reading of powers is probably more important than the description of the rights themselves in the Bill of Rights or the Constitution. And that much of our freedom flows from the fact that we have essentially a reciprocally opposite way of approaching the text. So that's my story about the vertical organization of the Bill of Rights, that if you look at it vertically, it tells a remarkably coherent story. If you, let me just quickly give you an example of a horizontal reading. Take the First Amendment. The First Amendment has 6 ideas in it. The 6 ideas unfold establishment, free exercise, speech, press, assembly, petition. They unfold in six ways. If you think about that for a moment, that's a remarkably coherent story. That is a series of concentric circles that go from the inner sanctum of the human conscience, our establishment clause being the deep conscience that you don't want to support something that you deeply disbelieve, with religion being the strongest kind of conscience the founders knew. So you go from a protection of conscience in a series of concentric circles, with each concentric circle adding to the number of people and the nature of the communication. So you go speech, which is individual discussions, press, institutional discussions designed to reach a mass audience, assembly, people getting together as a result of all of that information, and petition, people actually then interacting with their government to bring the ideas into being. And I think it is not unfair to say that the First Amendment gives us the life cycle of a democratic idea. It is the founders' understanding that in a tolerant and free democracy, ideas begin in the protected nature of the human conscience and move in concentric circles toward final establishment or ratification into law in a series of carefully modulated circles. So I'll end by saying when Justice Harlan in NAACP versus Alabama dropped a seventh non-textual idea into the First Amendment. Freedom of association is not textual. It's not in the First Amendment. Justice Harlan dropped it in NAACP versus Alabama. He was acting in perfect accord with the ethos of the Ninth Amendment, which told him that he could use equity of the statute to look at that document and say, is there a lacunae? And using the techniques of British lawyers under equity of the statute, can I fill that lacunae with something that is compatible, analogical, and necessary for the full enjoyment of the text, which was the British equity of the statute. And it's why, over time, even groups like the Federalist Society, who understandably are concerned with non-textual judging, tend to accept the Harlan Formulation as appropriate. Because the Harlan Formulation is exactly what the founders were thinking. You fill in a left-out blank in the First Amendment by reference to the power given you in the Ninth to construe it broadly and analogically, but not completely openly. You must comply with the notions of equity of the statute. So I think read that way, it helps us understand the Ninth. It helps us understand the First, and it also gives a possible help in understanding the Second and Third. It explains why the Second and Third are where they are, because they're so important, because it was to protect against military overthrow. So with that as my sort of general thesis, I'll try to, I probably have not stayed within my time limit. In my life, I've never stayed within my time limit. I expect when the Grim Reaper comes for me that I'm going to ask for a couple more minutes. So thank you very much.
Actually, Professor Neuborne did indeed stay within this time limit, and now we will hear from Professor Barnett.
Thank you, Judge. Now, it's always a pleasure to appear on a public panel with Burt Neuborne, who is the epitome of a law professor who is both a gentleman and a scholar. And I'm particularly pleased to comment on his very interesting article describing a holistic approach to the Bill of Rights. Now, there is much in the paper with which I agree, and you heard some of that in the summary. And even where I disagree, I found that I learned a great deal from it. And that is not always my experience with constitutional scholarship, I should say. Now, Burt's meticulous organizational scheme by which he explains the order of the amendments as well as the order of the clauses within each amendment is ingenious and maybe even correct as a historical matter. And by the way, for those of you who are getting ready to run to the microphone to tell him that the First Amendment was really the Third Amendment because you think this is a great gotcha moment, he knows about that. He talks about that in his article. Save your comment for something else.